My lord, may I permit to mention, my lord, item number, my lord, 106 and 107, my lord.
Give all the inclusions. If anybody wants inclusion in the list, you give.
Motion inclusion.
Yes.
Permitted to mention.
Yes.
My lord, may I permit to, my lord, this matter 106 and 107. My lord, both sides present here. My lord, your lordship heard this matter, my lord, most of the only one, my lord, circular was not available, master circular 31.
When it is
So,
taken up, sorry, yes.
My lord, any day, my lord.
No. Yes.
Permitted to mention item number 12 of your lordship's today's list. Well, at the time of rising, I mentioned this matter. Your lordship was pleased to direct me to mention it today. Well, my client, the petitioner himself, has attacked with a cerebral attack.
What do you want?
His bed. Well, let it be adjourned till at least 3rd March.
Monthly list of
As prayed, recording. You are for
12.
petitioner. You are for the
I am
petitioner.
for the petitioner.
As
This is disability pension matter of army. I'm facing contempt. 133 of your lordship list. It will be tagged along with the several matters which you will already, your lordship has passed an order. 133.
it has to be tagged with which matter?
WPCT 234, which your lordship has yesterday also had taken.
Mentioned, put yes, take it on to be mentioned.
Much obliged, your lordship. It up. 100.
Tomorrow or day after, any day.
106 and 107.
Tomorrow or day after, to be mentioned.
106 and 107 was heard by my lord
How many times you will mention the same case?
My lord,
There are so many matters which have been argued and adjourned. They are not all to be taken up out of turn. Yes.
your lord.
My lord,
Anybody else?
permit to mention one WPCT matter is running in the list as item number 192 for upgradation lordship.
Why?
Lordship, there were total 8 petitioners. Among 8 petitioners, 2 were already, they have been offered appointment by the railways. They are the land losers. And Lordship,
When it comes, you argue. Yes. I have
Lordship, may I
understood.
permitted to mention under one matter under extreme compulsion, Lordship. I am not getting salary for last 2 years,
You are not
Lordship.
alone, sir. Yes.
My lord, may I permitted to
Lordship,
mention-
kindly consider, Lordship.
My lord, I am going to file an appeal without certified copy, my lord.
Without?
Without certified copy of this order, my lord. My lord, we have applied for the certified copy on 27th January, but till now we had obtained the certified copy.
What is the last day for filing the appeal?
My lord, in Monday the matter was fixed on single bench, my lord. This is the urgency, my lord.
Arising out of an interim order?
Interim order, my lord.
No, you get the certified copy. Why? If the matter is already fixed, that the order must be available online.
My lord, we have applied for, but till now we had not obtained,
You
my
come
lord.
with the order. You have got this server copy.
Yes, my lord.
You have got it.
Yes.
All right, take it. You give an undertaking that you will file the certified copy.
Lordship.
Yes.
My lord, may I be permitted to mention WPCT 269, my lord, of 2024, my lord. It is fixed on 21st, my lord. I am led by DSG, my lord. Due to his personal difficulties, my lord, he will not be available on
It is
21st.
fixed only when it is taken up, it can be adjourned. Yes.
No, my
Anybody
lord,
else?
kindly prepone it, my lord, tomorrow, my lord, because on 25th there is a contempt, my lord.
We don't know. If it is fixed, it is fixed. It can be adjourned on that day itself.
My lord, for preponding, my lord, if it may be taken
Sorry,
tomorrow, my lord.
Cannot be done.
I've
sir.
given notice to the other side also, my lord.
You- Cannot be done, sir. Sorry. Yes. Call the list.
Grateful, my lord.
Item number 1.
Yes, my lord. This is my application. Yesterday, my lord heard
Yes,
this
we were taking up this. We had taken up this matter yesterday.
one.
At least today he is here. Yes. You issue notice.
Yes, my
Serve notice on the other side. Have you served?
Affidavit- Yes, my lord. I have filed affidavit service on the last occasion.
Serve again. Let them be here.
As your lordship pleasure.
After hearing the learned counsel for the party. That case, the busy gate was having a bit of
Item number 2.
mistake, but no, no, still problem to- None appears for the petitioners. If somebody had-
Item number 3.
I am for the respondent number 1, UPC in this question. Your lordship, if your lordship, please see the cost title. Your lordship will astonish that Union of India service to Secretary UPSC. How it is possible, I don't know, my lord. I only see respondent number 1, cost title.
Hmm.
UPSC is a constitutional body. How it is, how they made it, I don't know.
That is how it was in the tribunal also. That was the situation in tribunal also.
I never appeared in this case, I never appeared in the tribunal.
Did anyone appear for the UPSC?
In tribunal, I don't know, my lord.
So if it has been like this and without objection, then why it should be changed? You appear on behalf of the UPSC. Anyway, nobody is here today. It is a writ petition filed by the private individual.
My lord,
Same order. None appears when on call, matter list.
Item number 4.
I take to appear on behalf of the state government.
Yes.
Affidavit service letter.
Yes.
The question will arise that
You are for the private respondent.
I'm the department, CID, Criminal Investigation Department. Under my department, he has worked. This is employee.
now question will arise is why I am approaching before this type order of the tribunal. Your Lordship kindly says, if go through the original application, your Lordship kindly says, the poor humanitarian on the part of the respondent authority. Because Milord, your Lordship kindly says, what I have stated, the 21st January 2019, the husband of the petitioner has been expired. I made a representation for granting the family pension and other benefits.
21st of
January 2019,
yes.
22nd.
He was serving as
DSP,
DSP.
Deputy Superintendent of Police, CID, under state of West Bengal, Milord.
Yes.
CID. Thereafter, Milord, I made a representation. Entire fact, Milord, in the original application is there. After that, Milord, they have made an inquiry
You made a representation for what?
for granting the benefit, post-retirement benefit and the pensionary benefit, that is family pension. If your Lordship kindly take pain to go through the original application, your Lordship will find.
All right, we are
Then-
accepting it.
Then, Milord, one inquiry was made. That is on, I'm placing the date, Milord. Inquiry, Milord.
Who is Gautam Ghosh? Who is Gautam Ghosh?
Gautam Ghosh, one of the son.
Yes.
I do not know.
But do not know the son.
I do not know. I am, Milord, the claim he is the stepson. I am coming to that, Milord.
Yes.
But Gautam Ghosh said, no, Lily Ghosh and others and I have no relation. So that's why, Milord, I am also asking myself,
But why he should not be a party? That is the only issue.
what is the role of the inquiry CID officers? In Granta, I am producing all the documents, and the rule says after immediately within 30 days, they will prepare how to prepare who are the incumbent to get the benefit.
Why he should not be made a party? That is the only issue.
Only question, Milord.
Why he should?
Yes,
If you
yes,
say
that's
that
right, Milord. I am placing the what is the report.
he is claiming to be the stepson or whatever. But
I
it
have
is
to
a-
make party. Why authority has not been, Milord, determined who are the entitled to get the benefit.
Why he has not been made a party?
Herein, Milord, after 5 years, Milord, your Lordship knows why, what step has been taken.
Yes,
Your-
the order under challenge is only directing for implement of him as a party.
Nothing more.
There is nothing more in the order.
But your Lordship,
Why
can
we
see-
should interfere
your
in
Lordship,
this
can
order?
see for a moment.
We are not considering your claim. We are only considering what is the infirmity in this order that he should be implemented as a party. That is all.
What,
You
yeah,
cannot enlarge the scope that we
no,
will
your Lordship,
consider the entire claim here in the High Court
your
by
Lordship,
passing the tribunal where it is pending. What is
after,
wrong with
your
this
Lordship,
order?
after making the party, Milord,
Sorry.
your Lordship, kindly consider for 1 minute, Milord.
Yes.
The report, your Lordship, the report, Milord, that has been.
Has he been implemented?
No, till now.
Have you implemented him? Why not?
Your Lordship,
Why should you be shy?
your,
18 June is the next date.
Whatever is the next date.
Your
It's
Lordship,
only it's an innocuous order saying that he claims to be a son, you implement him as a
only
party.
question,
That's
what
all.
is the role of the CID officers?
We are
what is
not
the role
about
of
that. We are only
Why,
we are-
Milord, in terms of the DCR?
we are only considering the correctness of the order before us. We are not
Your-
going into why they have not settled the dispute till now. All those things are pending before the tribunal. You have approached the tribunal in 24 after waiting for 5 years.
Your Lordship, see the page 99.
We are not going to. What is wrong?
Immediately, Milord, immediately after the demise of my husband, Milord, I made a representation.
All right. Well,
Immediately.
take down.
Your Lordship, kindly consider.
Nothing
Your
can be
lordship,
done right.
kindly see the
At this-
after 99, I am
Sorry.
suffering.
Yes, call the next.
In the morning, pure millet have directed me to submit some money. We have submitted.
Yeah.
Your lordship, kindly
At
specific.
this stage, we cannot fix a time. Please try to understand. You have not even implemented him. Notice will have to go. We don't know. Yes.
But it is
we
not a
we
luxury.
expect, the learned counsel for the petitioner submits that he would be
I beg to pardon, Your Lordship.
5, I am for the petitioner.
Fine. John to court.
What is the affidavit service টা একটু রেখে দেবো। That what happened. Affidavit service টা দিয়ে রেখে।
কতবার হবে? হুম। তো ইম্পিরিয়রটা কই? ওই যে পুলিশ তো হুম হ্যাঁ দেবাংশুর অর্ডারটা আছে তো?
Yes, the matter. May I first place the facts of this case?
Yes, please.
This is a recruitment, relates to recruitment for the post of fire operator for the fire air and emergency services of the state of West Bengal. Advertisement was published in the year 2018. The notified vacant post is 1472. Now, we are the candidate, we participated in the selection process. After participating in the selection process, we have seen that they have published a list of candidates who are called for personality test without giving any marks. Immediately thereafter, we approached before the learned tribunal, state administrative tribunal. Learned tribunal and another issue regarding wrong answers keys in the written examination of for the appointment of fire operator post. We challenged 3 questions, and as well as the violation of reservation policy when the marks has not been provided to the petitioners and other candidates who have participated in the selection process, then the transparency would not be maintained. Now the learned tribunal dismiss our application. That is way number 170 of 2021. Dismiss the application on the ground of demurrer that we have participated in the recruitment process without objection.
Yes.
Subsequently, we filed a writ petition before this honorable court.
Yes.
That is WPST 44 of 2022. In the writ petition, the honorable division bench of this honorable court framed 5 issues
Yes.
and disposed of the said writ petition with a direction upon the Public Service Commission to maintain certain parameters in respect of preparation of merit list, as well as to maintain the reservation policy, all that. Kindly come to the order of the WPST 44 of 2022, which is from page 121.
What happened after that?
Parameter has been given. There is a the honorable court was pleased to give us chance to file an objection after publication of the list. We filed our objection.
After publication of final list.
Provisional list. Thereafter, they published final list without considering our objection. In our objection, we have taken a point that the candidate, we had this certificate in the recruitment process. There is a desirable qualification marks. Who has this swimming certificate from the recognized institution, he shall get 3 marks. Now, in my objection, we have given the instances that we have holder of the certificate institution. The same certificate holder candidate got 2 marks or 3 marks out of the full marks. But the petitioners are deprived from getting these marks. This is the challenge in the writ petition, that we are having the same institution certificate.
So they considered your representation, but they did
certificate has not been considered.
they did not allow the certificate to be considered to your benefit.
Yes, but other in the instance of similarly circumstanced candidate, they are favored by giving the marks, although they have the same certificates from same institution. Now what has happened? Kindly see the order impugned. Order impugned dated 9
So
January.
then why did you go to the tribunal again? Because they were not allowing marks for this swimming certificate.
Yes. There is a direction to order. Kindly see the impugned order.
So let
First
us
of all,
first let's see the WP.
WPST 44. Kindly
Yes.
see page 121. Page 121.
No, that would be better if you logically see page 152.
Sir, আমি একটু বলে নি তারপরে আপনি বলুন।
Let him place. You will be heard.
No,
Yes.
to shorten the time. What is the final analysis?
Yes.
That is 152.
What was the OA against which this WP was filed?
Selection
When-
process.
OA number?
Way number 170 of 2021. This is the first way.
And,
We have challenged
this
this-
WPST is number?
WPST number 44 of 2022.
And should we come to page 152 or you want to show anything else?
No. Kindly see, first of all, 121. Page 121, the order of the Honorable Division Bench of this Honorable Court.
Obviously, it is against OA. It has to be order of a division.
Yes. Kindly see, relevant portion is at page. This is an order dated 23rd December 2022, and the relevant portion is at page 131.
131.
131. What was the issues framed by the Honorable Division Bench? Firstly, may I read?
Yes.
Firstly, some candidate who offered their candidature under the general category who would be evident from the panel of interview subsequently published in terms of the order of the tribunal were accommodated and shown as selected candidate for appointment in the reserve category. Those who have applied as a general category candidate, subsequently they are placed in the reserve category candidate. That was our one challenge. Secondly, 3 questions are shown the wrong answer in answers key published by PSC. And since the modalities of the negative marks have been adopted in the examination, the candidate must given the appropriate marks in the right answer. In the selection, there was a negative marking. And kindly see, thirdly, the candidate who offered their candidature under the reserve category produced certificate issued by a competent authority after the last date of submission. In the recruitment process, in the advertisement, there is a condition that on the date of application, the candidate had to the reserve category certificate, but subsequently they have accepted the certificate from some candidate and gave appointment.
These are the grounds urged by you.
Yes, and kindly see the parameter which is framed by this honorable division bench, which is at page operative part of the order, page 152. That is vital. On context of the finding and reasons assigned herein below, the following directions are passed. 1. The PSC shall publish a phased merit list after scrutinizing the certificate not only pertaining to the caste, but also under the desirable qualification submitted by each candidate, and shall ensure that such certificate are in conformity with the condition incorporated in the advertisement and certificate issued by the competent authority mentioned therein, and shall also ensure that the such certificate is found in order are issued by the competent authority on or before the closing date of submission online application, that is 3rd July 2018. 2. After scrutiny of the certificate in terms of the direction above, the candidate who had included in the fresh merit list to be published, the PSC shall disclose the certificate of the successful candidates on the website portal for access of all candidates. They have published the certificate in terms of the order. So for the category of meritorious sportsmen are concerned, the PSC, after making a verification and scrutiny of the certificate, shall allot the requisite marks as disclosed in the advertisement, and shall also publish the breakup marks of each candidate in addition to the fresh merit list. The relevant certificate issued by the competent authority as mentioned in the advertisement shall also be uploaded in the web portal of the PSC. 4. The PSC shall ensure that the certificate submitted by the candidate under the reserve category as well as meritorious sportsmen are in conformity with the condition laid down in the advertisement, and in the event the same is not issued by the competent authority or issued after the closing date for submission of the online application, that is 3rd July 2018, shall reject the application, and such candidate shall not be treated under the reserve category but may be included under the unreserved category if the marks secured by entitle him within the zone of appointment. No appointment shall be given. That's the opportunity of objection shall be given to the candidates on the basis of the merit already published in terms of the order of the tribunal until the fresh publication is merit list. And the PSC shall complete the exercise within 2 months. And
According to you, they have flouted which direction?
The direction was there to consider the desirable qualification sportsman certificate, which has been given.
So, so Roman 3.
Meritorious sportsmen are concerned, the PSC making a verification and scrutiny of certificate shall allot the requisite marks.
Yes.
As this, now the instances I am showing before your lordships, kindly come to page 190. Kindly see page 190. I am showing just, I have 50 instances. I am showing
one is enough. You need not show 50.
Yes, 190. Page 190.
One instance of discrimination is enough.
Yes. Page 190. First of all, kindly come to page 188. 188, one instance. Apurbo Ghosh.
Yes.
Kindly see the Apurbo Ghosh name is middle portion.
Yes.
Serial number 1227.
Yes.
And kindly see the swimming, column swimming at the top. The heads.
Yes.
Swimming.
0.
And kindly next page, 189.
Yes.
This is the certificate of the Shark Swimming Club, recognized. It is organized by Hooghly Chuchro Municipality, Hooghly. And Apurbo Ghosh, such and such, was a swimmer of our club from 2016, and my certificate date 10th November 2016. That is prior to the advertisement. I am not allotted marks. Now kindly come to page 202. Page 202. কেন 202 টা আছে দেখুন, page 202, Vishwajit Ghosh, the serial number 384. Kindly see the swimming head. He was allotted 2. Yes, 2 marks. And kindly see his certificate, shark, page 203. The certificate issued from the same institution, Shark Swimming Club. Yes. Then kindly see page 204. Shubhankar Ghosh, 125 serial number, 125. Yes. Allotted 2 marks. Yes. Now kindly see the certificate 205. Shark Swimming Club. If they are favored by the 2, then we are entitled to get 2 marks. Yes. Now what has happened? Kindly see the order dated 13th August 2024 by the tribunal, page 416.
That's the order impugned.
No. The order where the affidavit direction was given.
300?
To 414, 16, sorry. 416. And kindly see my 416, my submission is recorded. Mr. Chatterjee re-emphasizes the earlier summons that his applicant were not considered for recommendation, though the certificate they possessed and presented were from the same institute, and in which many successful candidate had obtained. Mr. Chatterjee ready to show copies of the certificate obtained by the applicant, certificate obtained by some of the candidates recommended to the post of prior operator. The order of filing reply rejoinder was given. Now kindly come to, they have not filed any reply before the tribunal regarding the allotment of marks to the candidate who have the same certificate.
No reply filed.
No reply has been filed.
No reply whatsoever, or in the reply they have not dealt with this.
No reply has been filed.
All right.
And kindly see the order impugned once, which is at page 426. No, that is the impugned order is at 424. আছে তো আপনার কাছে আছে তো? হ্যাঁ বাস। এলপি অর্ডারটা আছে।
What is your relief in the OA? Let us see.
Kindly see. Which is at page 106. No, dismissal order. In the way, I have not challenged the wrong answers keys provided by the PSC in the written examination. And the tribunal was of the opinion that we filed an SLP, we challenged the both order by filing the way in the way application, our challenge regarding the certificate
Who
allotment of.
didn't file SLP? State followed SLP.
No. I filed the SLP. We had the SLP filed.
You
on
have
the
filed SLP against the order of the division bench.
partly challenge the issue of wrong answers key of the written examination. Kindly see, I attach the ground of the SLP
So how
petition.
can you comply with and challenge the same order? You are seeking compliance of the same order which you have assailed before.
No,
the
I have
effects court.
challenged the part order, part of the order. Kindly see the Supreme Court petition I have annexed.
Where is that?
Kindly see.
A part or whatever, the entire matter is before the Supreme Court.
As a whole, I have not challenged.
You may have not challenged.
I challenged the
but
wrong
the
answers key. Kindly see, that's why I
If the long answer key is allowed, then what will happen?
we
It's not severable, sir.
then
It's
we
not
are
severable.
then we are entitled to gild the marks regarding wrong answers keys. But the
That
certificate
will
issue is
change the
different.
entire. Not only you, thousands more will get those marks. We don't know where you will be.
Absolutely. That
We
will
don't
be,
know where
that
you
will
will be.
That will be judgment in rem.
We don't know where you will be. The
Yeah.
entire context may change for you.
Kindly see the
It's not severable.
426. Kindly see. And 427, ground number 1. Just only we have challenged the 3 wrong answers keys, whereas the High Court was of the view that they are the expert appointed by the PSC is correct.
So you have filed a review also of the High Court judgment.
Review that was dismissed regarding wrong answers keys.
Where is that? You have not shown that.
Reviewer attack actually. Not a video. Page 62. That was also in respect of wrong answers keys. Thereafter, we challenged the order. Both. (62) of the petition. Review order. Kindly see.
How the court can proceed?
Kindly see the grounds of the SLP, my lord.
Maybe whatever we have
Kindly
seen
see
that. We are-
Roman 5, Roman 429. I attached the textbooks also before the Supreme Court regarding wrong answers key.
But we
I am
don't
not
find
placing
that,
the,
we don't find that in your SLP you have mentioned that we have also sought implementation of certain portions of the court's order.
no, I have not. I have not, admittedly, because I have challenged the part of the
Can you-
order.
That will, whether that will,
Because
I don't know how the Supreme Court will take it. But whether you are, such a recourse is open to a petitioner to suppress this vital aspect that I have sought implementation
No,
of
no, we are
certain.
not suppressing, my lord. We are
Oh,
not suppressing.
non-disclosure amounts
I
to
am-
suppression.
I
sir.
am on the, I am this,
We
just
are
on the
on
issue
this.
of,
We are on this. Had you been fair, had you stated before the apex court that, look, we have also gone for compliance of the part, then what you are saying today may have been, we don't know. We can't say for sure, but then right now, as far as the apex court is concerned, you are challenging the judgment on a particular ground.
particular
But
ground.
that does not preclude the appellate court from going into the other grounds, and they will file their response.
That point has not been agitated before the Supreme
You
Court
may
regarding
not have,
certificate.
you may not have, but the respondents will have to be heard. Nobody knows what will happen there. It is just at the filing stage. You have not disclosed that, look, I have gone for implementation of certain aspects. How the lower forum can proceed to consider the matter? How it can?
Well, SLP has been dismissed on the ground of wrong answers keys.
Already dismissed.
Dismissed.
Where is that dismissal order?
Dismissal order. এটা প্রিন্ট আউট তোমাদের
When it has been dismissed?
Yes, 28 January 2025.
You bring it on record.
Yes, 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 yes.
We are informed that the
Before the tribunal regarding the certificate issue. We are, my lord, prima facie able to satisfy your lordship regarding the
but this
certificate.
development you can go and show to the tribunal that, look, now nothing is pending
Tribunal
before the
says that SLP dismissed, that's my right.
So therefore, we don't know what we'll do, but we think now in view of this development, tribunal can consider. We'll see what the order.
Prior before the SLP, entire challenge for set aside the order of the High Court.
No, they have not.
No, prayer in the
Monday, I will be with my SLP petition. Whole SLP petition. I am just attached the ground to satisfy your
But then
lordships.
the petitioner should have disclosed before the apex court. Fortunately, your matter.
Yes. Yes, 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 yes. I was under the impression, my lord, I was under the. Yes. Let me go through my SLP petition. I shall produce the copy. Yes. ঠিক আছে দিন আপনি নিন আপনি জানেন না এসএপি কমপ্লেক্স
Item number 6.
Make to appear in this matter for the
এই প্রীতম
boy. It's serviced. Xerox code. 2 कॉपी लगता है बोले विथ लिस्ट my lord, before starting my submissions, my lord, that I have served upon all the respondents, my lord, one copy is, my lord, not been Xerox. My lord, in course of the, I shall file the copy of it. My lord,
before going to the impugn order, would your lordship allow me to 1 minute? Then your lordship can. My lord, in normal or plain reading, my lord, from the order impugn, that the learned Central Administrative Tribunal, my lord, proceed with the matter on the basis of a defective applications of the petitioner which has been submitted at the time of resignation of his service. Number two, my lord, that the learned tribunal failed to, my lord, give an independent opinion with regard to the issue which has been formulated by the court below in respect of the subject matter is concerned. And third, my lord, after rendering almost 20 years plus service, my lord, the entire service benefit was forfeitures. My lord, only I am putting this question to myself, my lord. Right of livelihood. A person at the age of 50 odds, my lord, due to lordship, and it come to my page 32. Or your lordship can take trouble to the same. No date.
No date. Come to page 32. How you are saying no date?
12 April 2006. It has.
Why do you say no date?
No, my lord. So for the date of effect of the.
We didn't ask you effect. We said
Lord.
what is the date of application? You said no date.
Your lordship, correct.
Where is the first application made by you for grant of any benefits? The first application made by you for grant of any benefits after your resignation.
Lordship. My lord, if your lordship kindly come to the in 2020.
The first application.
Lordship.
Where is that?
To the
Where is that? At which page?
I just Lord 11/8/2000, which was dealt by the Deputy Commissioner.
Where is your first application, sir? We are asking you.
Page 32A. And another letter, my lord, page 30. Page 30.
Come to page 82. That is your first application.
Lordship.
What is the date? August 2020.
Lordship.
24th
Yes.
August 2020.
But if your lordship take trouble, page 30, lord, there is
No,
a
that was not before the tribunal. Why should we see 30?
No.
That was not before the tribunal. That is a not dated document and that is not before the tribunal. So that is not required to be considered. Your first application is of 24/8/2020. Prior to that, there is no application. And that also, it appears that after some form for GPF and KVS was sent to you for some benefits under the employees welfare scheme.
Lordship.
Thereafter, you said that please sanction my pension also. After 14 years. What is wrong with the tribunal's assessment?
Lord, my humble submission before lordships.
Yes.
Lord, the order which has been passed by the tribunal, on the basis of, I again reiterated my submissions that the first prayer of my tendering my resignations, my lord, there is no date wherefrom I tender my resignations. First point. Subsequently, in reply to the letter of school authority, I have been reply from the date of submission of my applications, you may consider. First point. Second point, the order, which is the subject matter of challenge, my lord, the learned tribunal, it not mentioning any independent observation with regard to the why they deny in respect of the claim of the petition. So for the statutory provision enunciated in the law with regard to the section 26, which is debarring the petitioner to get the service benefit or feature or intendment of the entire service benefit. My lord, here I try to assess your lordship, my lord, just joining the issue that after rendering my 28 years service, and at the over, my lord, now my lord, I am a senior citizen, my lord, and at least had there been any provisions for issuing any my lord, invalid pension in respect of the petitioner parties concerned? Because I have no authority.
Yes. Did you file any rejoinder to their reply
Lordship,
before the tribunal?
lordship,
Where is that? Which page?
lord, at page 104.
Yes. Thereafter, you have specified a date, and with that date, they have accepted it.
Lordship, because in the body of the order, it has been enunciated that I have submitted applications subsequently in reply to the school authority. I have been further communicate with them. From that day, they have been accepted this my resignations.
That fact is there. It is,
Yes, it has been mentioned. I cannot escape from there.
it is in the record also. It is.
My contention before lordship, your lordship correct. As my first application is a defective, and without specifically did not mentioning with regard to this, whether that the authority concerned proceeded on the basis of a defective subject to kind sanction, because I try to improve a very small points because my entire livelihood was taken away in the initiation of a proceeding of a defective late.
What proceeding has been initiated? What? No
Simply,
proceeding.
Well, correct.
Why are you saying proceeding initiated?
Or,
No
or,
proceeding
or
has been.
impugn order, rather I could say the impugn order for termination.
Proceeding, no proceeding is there.
And as a consequence of that, my entire service benefit was including my pension.
Where is the subsequent letter that you wrote to them?
Against the rejection order, I straightway approached the learned tribunal for challenging the word for setting aside the.
has completed the this case. So can be 2 days after invoice. But VRS cannot take the after completing the qualifying service. The option of doing that before option.
Shoot করি।
Right, then they have accepted. This fact has not been because they have said in that right. She has clearly specified the date. Which they have said in paragraph 3. Apply to paragraph 3. They have not denied. That they are approved. And because this case that he found some effective which is actually PRS for the UCRB the service groups of the state government, the union government, and which
So, Lord, taking into considerations of Lord, the after rendering 28 ordinary service, and he crossed at the now he's a senior citizen. At the material point of time, he was 51, 52. Now, my Lord, had there been any because I could have been understood that so far the prescription formulated in the my Lord, CCR rule is concerned that mere tendering my resignation forfeiture my service benefit. But here, a a sub a letter which is not comprehensive and it is my Lord, defective. So on the basis of defective, I think they cannot pass any order. And that apart, the order which has been assailed by the past the learned tribunal, well, they did not given their own independent observation why they are rejecting the claim of the petitioners. Well, in these two aspects, Load Xerox copy.
Rule 26 is perhaps the relevant rule. Where is it? Please,
Xerox copy. WBS sir. CCR. CCR.
PCA pension rules. Get 2 copies. Yes, Swami's compilation.
Swami compile.
Swami's compilation.
Xerox.
Get 2 copies.
ব্যাগটা আনে না ব্যাগটা নিয়ে আসতে হবে ছেলেগুলো সব কি
Is not.
stop.
26 has been quoted in the order.
Lordship. But it has not been recast. So far your lordship's query is concerned. It is only simply mentioned. It's not been set out.
What are you saying?
My submission before lordships, my lord, that with regard to the pension part is concerned, that pension is the property of the incumbent petitioner. That cannot be taken away by simply.
Nobody has taken away. You have given away. There's no question of taking away.
Rather,
Cannot.
I stand corrected to my
Yes.
submission, Lord, that
And what is yours, you can give.
lordship, Lord, that cannot be.
What is yours cannot be taken, but what is yours, you can give. You have opted to give.
So
You
far-
are a benevolent employee. What can be done for you, sir?
Lord, I got your lordship's view, my lord. But
Yes.
even then, my lord, I try to assist lordship that property can be accepted by the. My lord, I got your point, lordship, my lord. Because I try to assess so that you'll. Mhm. 20 subsection 4. Central government. My lord, I just, your lordship, my lord. So for the paragraph 8 is concerned, where my learned code below has been giving reference with regard to the resignation has been effect of termination of an employee and the entitled consequence different from that a voluntary retirement, and pension cannot be claimed in the former case. The Honorable Apex Court has also held in another case held that even the respondent has served 20 years. Served 20 years. My case, I have tendered 20 years odd service, number one.
Whether 20 or 21 or
number is
10,
noted.
that is not relevant. Whether qualifying or not, that is all that is relevant.
It is a qualifying service of
That is, therefore, number of years is not relevant. For central government, it is 20 years. For the state government, it is only 10 years.
Paragraph 6 up to 5 set out of all the records, and 6 onwards the quoting of the Supreme Courts, and there is no such independent observations with regard to the rejection of the case of the petitioner has been set out or mentioned in the four corner of the application order. Uh, 26 subsection 4. Subsection 4. अभी 26 चलें हमें देखें. No, I don't know, Jimish. It appeal. Better not. Pension rules. Very good. Patient is not raising that point wise. Even now. It was listed after that case. Yes. Resignation. Resignation. Request for withdrawal. Right?
Please. এগুলো রাখো। আমার একটা নতুন এসেছে, আরেকটা বলো, আরেকটা বলো, আরেকটা বলো। আরেকটা তো দিয়েছো তো, একটা ষোলো।
You're sure to keep. Yes, before time. Malud,
The order is passed by a single administrative member.
Lordship.
What lordship? We are asking you, we are waiting for you to make that point. You are not making any point.
Correct. Malud, we are learning from your Lordship day by day because something we may be miss. But so far your Lordship's view is concerned is far reaching. Obviously, Lordship. 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 So kind of. Lordship. The Lordship pleasure to just only simply admit this cause kept pending.
No, no, after 4 weeks.
So kind of. Good.
Does anyone have the, does anyone have that?
The cat has filed the reply application. I guess that all. Pending আছে না? Yes, that's right. সেইটা কথা বলছে বলছে। Review is saying the same thing. Same thing is.
We are waiting for him to make that sub.
Well, I was in a different aspect. You all should correct. We are learning it. Hey, sir. So kind of.
Item number 7.
My lord, 7, I am for the petitioner, my lord. My lord, I am filing my affidavit of service. My lord, I am for the petitioner, my lord. My lord, petitioner is firstly, my lord, petitioner is a senior citizen at present, and she has been working for more than 20 years as a in a nursing department of Arjikar. So, my lord, kindly come to page 78 of the impugn order, my lord.
This is your claim.
My lord, my claim is that to revise my pension.
Revise.
Yes, my lord. My lord,
As per ROPA.
as per ROPA 2009, my lord. My lord, I am.
When did you retire?
My lord, I retired on 2008. According to ROPA 1990, my lord, I am entitled to get scale 10, which I'm not receiving at present also. According to them, that I have opted that option. But my lord, I was not known to that only.
You have exercised the option. How can you?
My lord, I was never known about that exercise, my lord, of that notification, that because I was busy on my duties. When they have published that one, I was never known to that one.
But that is of 2009.
My lord, yes.
You are approaching the tribunal in 2020.
Yes, my lord.
And you retired in 2009.
My lord, 2008.
In 2008. Can be done after at such a belated stage. If there was a mistake, you would have realized, you would have come immediately, then maybe there would have been occasion. No, at this.
My lord, that time she was not, my petitioner was not in that stage to come before the tribunal, my lord. And even after, without hearing me, tribunal has passed an order, my lord.
Yes, 90. What is CAS?
My lord, that is, my lord, that is career advancement scheme.
Can you see the requirement? It is 2008.
2008.
2008. And exercise the options 2009.
What is that option?
Option would have particular desired pay scale. It's called West Bengal Service Revision of Train Announcement 1951, 1990, 1999. In 2009, 2019. Plus.
No, these are the years in which the pay has been revised.
Yeah, because that option has to be accepted. Whether I will accept it. Because something pay scale of teachers. And on the route 4, sorry, fix suppose 4, that once the option itself is sufficient. And we filed in 2006. 20. We filed in 2008.
My lord, that cannot be the ground for my not revising my pension.
Can be.
That can.
Delay defeats your right.
My lord, she was.
So much delay.
My lord, she was not physically fit for that time.
Maybe. We don't know.
And she, as at present also, she is not fit.
Maybe.
My lord, she is bedridden.
No infirmity in the order. Where is your option? Which page?
My lord, on several occasions, I have done the representation before the concerned authorities also.
You have given the option
No, no, no.
2009.
No option I have given. I haven't been known about any option, my lord. That's my,
See, please submit whatever is there on record.
yes, my lord.
As per your OA, after 2009, when did you submit the representation?
Representation, my lord.
Yes.
My lord, kindly take my
Page 64.
64.
Cash benefits of 1990.
My lord, kindly take page number 35. That is my first representation before the concerned authority to the superintendent of Arjikar. On several occasions, I have made representation, my lord.
By making a representation.
That does not suffice. Even, my lord, the deputy director of health commissioners, health service personally also sent this to before the Arjikar for considering my representation. That is on page number 42.
And when was it finally rejected?
My lord, file was rejected on 11th January 2024.
No, the
No, no.
authorities, when the authorities have rejected.
My lord, they haven't rejected. They have sent the file, but no actions
No
has been
action
taken.
was taken.
No, my lord.
They have sent the file. Which application they have forwarded? Your 2009 application or any other application? That's why we are asking you, why don't you show us from the OA what is your case?
My
What
lord,
have you
that
said?
only I am showing, my lord. Because
You are going to the documents. What is your case? You must have said that when you filed the first application, what did they do?
Wait a minute.
it's for 18. My lord,
20.
my lord, from 20, my lord will get my OA. There's the relief facts. My lord, facts I have said that she should get the benefits of ROPA
We
2009.
are asking you a question. You are saying everything but replying to that question. Just let us read, please. Wait.
Page 32, kindly see prayer. So what rules started? The what rules 2009? Yeah, sir.
You can answer again.
Where is the provision regarding exercise of option?
Rule 6, sub rule 4.
My lord, may I give?
You have the rule.
Another copy also, my lord.
Six. Now kindly see rule 6 option. Sub rule 4. An employee who option once exercised shall be final. না তোর এই আরে বিপটা তো পড়ে না বিপটা তো তুমি বাড়িতে পড়েছো না নতুনের কথা নয় আমি বিপ পেলে রাতের বেলার মধ্যে পড়ি রাত্রি বা একটাই হোক বা দুটোই হোক
So her option is under the first proviso.
exercise of option. The person option on the provision to rule 5 shall be exercised in writing in the form appended to schedule 2 so far it is the authority mentioned in sub rule 2.
No, we are asking you to see whether her option is under rule 5, first proviso to 5, or you are going to 6. We are asking you to see the 5 of the
yes
rules, rule 5.
Rule 5. Drawal of pay in the revised pay structure.
Yes.
Save as otherwise provided in these rules, every government shall draw the pay in the revised pay structure applicable to be paid which is appointed, provided the government employee may elect to continue to pay in the existing pay scale until the date on which he earns his next or any subsequent increment in the existing scale or until the vacancy is post or ceases to draw his pay scale.
Yes.
Provided for the case where the government employee has been placed in a higher pay scale between period from 1st January 2006 to the date of notification of the rules on account of promotion, upgradation of pay scale, etc. Such government employee may need to elect switchover to the revised pay structure from the date of such promotion or upgradation as case may be.
So which therefore we are wondering, we don't know whether she has been granted any promotion in between 1st January 2006 to 2009. It doesn't appear so.
No.
So probably it is the exercise of option under the first proviso.
One exercise options, rule 6.1. 6.1.
No, 6.1 is the method of exercise.
Then,
The rule 5 provides the option of exercising. Rule 5 provides the scope for exercising option. How it is to be exercised is provided in rule 6.
Yes.
Now rule 5 says there are two conditions in which rule 5 says revised scale will apply to all except those who exercise an option. So the exercise of option is under two conditions which are contained in the proviso. Her exercise is under which option? Proviso 1 or proviso 2? Did you file a opposition before the tribunal?
Just give me 1 second.
Nothing has been filed, my lord. Nothing has been filed.
You file an see, please try to understand what we are trying to ascertain, because the prima facie it appears, and I don't know what is the legal position, whether it has been considered by any court, that these rules government shall draw pay in the revised structure applicable to the post to which he is employed. Every government employee shall draw. This is a mandate of rule 5.
Yes.
Now there are proviso always provides the exception to the main provision. So the proviso is laying down the exception that under such conditions one may opt not to.
Not to accept.
So therefore this is an option. If it is an option under the first proviso, then that option will lapse.
Yes.
That option will not continue. Just read the first proviso, please.
Rule 5.
Yes.
Provided that a government employee may elect to continue in draw pay in the existing scale until date on which he earns his next or any subsequent increment in the existing scale or until the vacates his post or ceases to exceed.
Yes. Only till that date. Then the option may lapse. We don't know what is the position, what is her option, whether, or if she has earned a promotion between 1st January 2006 to 2009, then she may opt to take the promoted scale instead of the revised scale. Whether she is covered by first proviso, second proviso, from her facts it is not apparent. She has not pleaded. But just file an opposition, we'll see what is the position. And the learned counsel for the petitioner submits that cannot be withdrawn. That is correct. It's the right option. See how
Item number 8.
Your Lordship, I am for the petitioner. The ground which I have challenged the writ petition, my lord, just during the course of my preparation, my lord, I found that is contrary to the records, my lord. So therefore, my lord, I need to take instruction from client, my lord, if I file my supplementary or I will withdraw, my lord. Otherwise, it will be prejudicial to the client, my lord.
And counsel for the
Item number 9.
Item number 9, my lord.
But this is my appeal, my lord.
Item number 9, my lord. Mr. Devabrata sir is appearing for the writ petitioner respondent, my lord. I am praying for not today, my lord.
you were the writ petitioner.
Respondent, my lord. And in 11 also, I am the private respondent. My learned senior friend is appearing for the appellants.
I was not made the party. There are two applications. One is the leave to prepare appeal, and can one is the leave to prepare appeal, and can two the stay of the opposition to the order. I was not made the party. An interim order passed by the learned single judge, which ultimately affects my right, and that's why
So why can't you go before the honorable single judge for
that? That is why the preliminary objection is that the writ is not maintainable at all at the
So
instance.
therefore, this cannot be raised before the single judge.
That's why, like, the interim order without making me, that's
So why
that is the only problem to me, that how one single judge passed an interim order which ultimately affects my right without making my
apply for impleement? You ask for vacating the order.
there are several judgments for the interim order at least cannot be passed.
Maybe.
Injunction cannot be passed. Restraining someone who is not a party to the proceedings which is pending, that is that's why. Have you lordship kindly take the only this order under challenge.
Thereafter, no order has been passed in those proceedings.
No, not as yet one.
Kindly takes it up at 2, my lord. Because one matter is going on.
Maybe lordship kindly come to one.
All right, 2 p.m.
2 p.m. Lordship. Grateful. Both matters 9 and
2 p.m. we have a matter fixed. We'll take it up before rising. Ask him to come.
before rising.
Then let it be taken up tomorrow, because 2 p.m. if lordship.
Tomorrow.
No. Before rising.
You want tomorrow?
Because
No,
2 p.m. if your lordship is not before rising. My lord, before rising.
Without listening.
My lord, before rising. I haven't talked.
Grateful.
Bring it. Ask them to get.
Item number 10.
My lord, in this matter, on the last occasion, your lordship was pleased to see the PIL copies filed before the Chief Justice. Whether your lordship wants to see. My
It was not an appeal, it was a PIL.
PIL, my lord. My lord, at the first round of litigation, I have filed a writ petition before the learned single judge. Learned single judge is of the view that
It's
the
a PIL.
grievance of the petitioner, it at best be a PIL. So I went to the PIL court. PIL court dismissed that holding inter alia that I have a direct interest in the matter. So I went back again to the learned single judge, the honorable single judge, that PIL court has stated that I have a direct interest. So my writ was dismissed, holding that I am not the patent holder.
You are on?
I am not the patent holder, which was not at all subject matter in the writ petition. I have never pleaded. I just introduced myself that I am the patent holder, which I cannot suppress, but I have not made any pleadings with regard to my patent in the writ petition.
If you are having no claim with respect to your patent, then what is your claim pending?
My lord, my represent, I have submitted a representation to the Secretary Transport that whether unregistered plying of illegal business and operation.
Only that.
Only to that extent, which is my representation. I have prayed for consideration to that extent only. And my prayer was only limited
Therefore,
to that.
if you exclude that, then again it becomes a PIL. If you exclude that, then it again becomes a PIL. Because you're a patent holder, the PIL court said that no, it is your personal interest. Now you are saying we are not interested in the personal interest.
I am the patent holder. That is right.
So there,
I am the patent holder.
You have to be very clear on your stand.
My lord, I am.
Unless you are clear on your stand, nothing can be done.
My lords.
And
my humble submission is that I am the patent holder.
the moment you say that you are a patent holder, then the issue of patent is a relevant consideration.
My lord, then my lord, I take.
Then there is not. Then the order has to be seen whether you are a patent holder or not.
My lords. Then my lords, may I take your lordship to page number?
What is the order passed by the honorable single judge? That
my lord, page number 90.
And whether this is the proper forum for declaring whether you are a patent holder or not.
My lord, I proportionally agree with the honorable court's view that this is not a proper forum to adjudicate these issues, because it has to be this is a private law domain and it has to be decided by the suit court. And suit court has already recognized my right as a patent holder.
Yes.
Suit court has already recognized my right. I am having the injunction order. That injunction order was challenged before the honorable division bench. The division bench dismissed the appeal. It was challenged before the Supreme Court. Supreme Court dismissed the appeal. So, my lord, I am having all the orders. And in the writ proceedings also.
Injunction does not mean that you have been declared a patent holder.
My lord, may I take your lordship?
So that is an issue which is yet to be determined.
My lord, may I take your lordship to page number?
It may take us to all the pages. We will not stop you. We are asking you that at this juncture, when the issue of patent is pending, can an order be passed treating you as a patent holder?
It's not pending, my lord.
Yes.
I have filed a suit for infringement of my patent.
Yes.
And in that, before the original side of this honorable court, and in that suit, an injunction order has been passed.
Injunction against the state.
Against the state.
Yes.
Two suits were pending. One is before the Alipur court and one is before this honorable court.
What injunction has been passed against the state?
Restraining the state respondent that not to register any rickshaws till disposal of the suit.
So if there is a violation of the injunction, then the writ court is to take up that issue.
My lord, I am not on that. That's why
you are on that. Therefore, we are asking you to decide what you are on.
My lord,
you have to decide what you are on.
My issue is different in this writ petition, my lord.
Yes.
My lord, I have made an introduction that I am the patent holder.
No, you are claiming to be the patent holder.
I am claiming to introduce myself as a patent holder.
No, you be very specific. Should we record that your prayer here is not dependent on your being a patent holder? You are not at all raising the issue of yourself being a patent holder. Should we record that and proceed? Or should we record that you are a patent holder, therefore you want this relief?
My lord, whatever court deems fit, my lord, I have.
No, we'll record your stand.
My lord.
We are asking you to take a stand. We know we can do whatever we deem fit. For that, we don't need your permission.
My lord.
But we are asking you, what is your stand? You can't travel on to.
My lord, I am the patent holder. Need not to be required to be recorded, my lord. Need not to be recorded. I am the patent holder.
Then you go before the suit, pending suit. If there is a violation of the injunction, why the?
My lord, I am not here for violation of the injunction.
Yes, you are. You are asking them to stop doing what the suit has already
No, no, I am
prevented.
not asking for stopping the registration, my lord. I
Then-
am not on that.
Then
My lord, may I take your
what is
lordship
your
to
prayer?
representation?
Show the prayer before the writ court.
My lords, my lord, my prayer is at page number 56, my lord. Thank you. A writ in the nature of mandamus commanding the respondent in the nature of mandamus commanding the respondent to immediately consider the representation dated 13/6/2024 received on dated 18/6/2024.
It is another.
Requesting for stopping
It
of
is
illegal.
it is a relief dependent on the issue whether you are a patent holder or not. This is also a relief dependent on the issue whether you are a patent holder or not.
Then, my lord,
You are asking a different kind of an injunction to be issued against the state.
no, my
First you said not to register, now you are saying not to allow any business.
illegal business, my lord. Section 39.
Not illegal business.
My lord, Section 39 of the Motor Vehicle Act mandates that every e-rickshaw has to be registered.
Yes.
And in our state, what happens? There were many unregistered e-rickshaws were plying. I am on that.
Where is the injunction? Show us the injunction.
My lord. My lord, may I take your lordships to page number 69, my lords? My lord, may I read, my lord?
We'll read. Just give us a minute. We'll read. Yes.
My lord, in this writ petition, my lord,
You are not party to the declaration of patent. You are not a party. Where there was a declaration of or an interim order passed with regarding your patent right, you were not a party. The
My
state
lord-
was not a party.
my lord, thereafter, my lord, in presence of the state,
That case, state was not a party.
my lord, in that case, state was not a party.
All right.
But
now
Honorable Justice, His Lordship, Honorable Justice Somensen Lordship, who has granted the injunction, has given the notice to learned counsel for the state, Mr. Puripastina, for
the
intimation.
interim order injunction does not operate against the state.
My lord,
Yes.
I agree to
We
this
are clear
proposition.
on that.
I agree to this proposition,
Yes.
my lord. My lord, in this order, my lord, one more observation was recorded that court is prima facie satisfied that the plaintiffs who are the writ petitioner herein are the holders of patent in respect of technology applied for battery operated
That may
equipment.
be a prima facie finding that has no value.
My lord,
Yes.
hereafter, my lord, what happened?
There is no final declaration to this effect.
My lord, thereafter, what happened, my lord? May I take your lordship to page?
Therefore, till date, there is no declaration of
My
patent
lord,
in your.
there's a declaration by learned Alipur court which was upheld by Supreme
Where is
Court.
that? Show us.
My lord, I am taking.
No, show us that because you are claiming the entire rights as a patentee.
My lord,
Show us declaration of patent.
my lord, my humble submission is that, my lord, I am informing whatever the court wants to know.
No,
My
you have to
submission-
inform us whatever basis you are claiming a right.
My lord,
You are claiming a right by virtue of being a patentee. We have yet to see a declaration of your being a patentee against the whole world. A judgment in rem. Show us. Where is that?
next. এখানে তো এটা নিয়ে issue ছিল না।
That
দেখি
was
যে patent লাগানো আছে।
GA 33878 was only with respect to one defendant. You sought direction against him and that
My
was
lord,
allowed.
My lord, my patent certificate is annexed is at page number 17, my lords.
Page number
17, my lords. 17.
That is enough.
My lord, thereafter, my lord.
That is enough. Tell us, please. You know the legal position. You have been contesting a suit. That is enough.
My lord, one more humble submission, my lord. One more humble submission.
We are asking you to make submission because you are contesting in person. You are also a qualified lawyer, which we have seen from the pleading. But that is not enough.
My lord, the Alipur court's order is not with me. My lord, if a short password is given, I will bring the
Not
Alipur
today.
court's order.
Not today.
My lord.
The only thing, my lord, may I come on the next day? My lord, a judgment. My lord.
Want it to be tomorrow?
No.
In presence of, you are for the state.
You am for the state.
Yes, take down. In presence of the learned.
তো বইগুলো লাগবে বুঝলা কিছু অর্ডার জাজমেন্টের অফার
Item number 11.
Item number 11, my lord, I'm having the same prayer as item number 9. Item number 11, my lord, I'm having the same prayer as item number 9, my lord. Can it be taken up at 2 p.m.? It's the same matter, my lord. Mr. Shahro is appearing on behalf of the private respondent in this matter. Yes, ma'am. Let it be taken at 2 p.m.
time of rising as your lordship.
Matter we have said before rising.
Yes, my lord.
As per your
Much.
We'll take it up at 1, 10 minutes.
Item number 12. 13. 13.
চলুন না চলুন একটু I am for the
Eric petitioner, my lord. My lord. এই যে 13 রেখেছে। My lord.
Respondent in class.
Suju. My lord, 13. My lord, I am for the petitioner in this matter, my lord. I file a short supplementary affidavit in this connection.
Depending on the respondent side.
My lord, no one here, my lord.
You have to hold your ground. Ground, not the other person. Not understand.
এইটা একদিন দিতে হবে, এটা সই করো।
Yes. None appears. None appears. Yes, yes.
My lord, I am for the state, my lord, Tapan Kumar Banerjee, Mr. At number.
My lord, Mr. Tapan Mukherjee is a respondent. Well, he is engaged in code number 1. No, no, no. One more time.
But I am playing for short person.
You have left such a senior case. The senior has left such a senior case. It's a case of 2003. Why, sir, repeated dismissal in default and non-appearance, and why you have kept it pending for so long?
Sometimes due to my fault, sometimes the court fault.
Sometimes due to?
Well, court faults.
Court's fault.
Court's fault. My lord,
very good.
I am suffering 3 times malignant malaria and last all my lord COVID. একটা কপি নেবেন, একটা সাপ্লিমেন্টারি এফিডেভিট। খালি আপনাদেরই করেসপন্ডেন্স। My lord, may I permit to file a supplementary affidavit in connection with this matter?
No, sir, no supplementary now.
My lord, only
we are not granting you leave to file any supplementary.
No, no.
First, make out a case. Let us see. Unless we give you leave, you don't file a supplementary. You cannot. Let us see what is the issue arising.
18th August 2003.
No, let him, please, Mr. Yes. Which order you have assailed?
My lord, 48. 48, page 48.
OA 902.
Yes, my lord.
OA 902.
Well, prior to that, I can state the facts before this. Huh?
18th August.
18th August.
পিএসসি কি পার্টি করেছো?
হ্যাঁ
পিএসসি কি পার্টি করেছো?
হ্যাঁ হ্যাঁ করেছি, সবাইকে পার্টি করেছি। সার্ভিসও করেছিলাম at that time.
Yes.
My lord, I can show before your lordship, the state of West Bengal has already admitted and
Where is the
recognized.
copy of your OA? Let us see.
ওয়েটা কোথায়?
হ্যাঁ
ওয়েটা কোথায়?
ওই এটা তো অ্যানেক্স করা নেই, খুঁজে পাচ্ছি না আমার কাছে। ওইটা আছে, এই তো অর্ডারটা আছে।
অর্ডারটা হবে না তো, ওই অরিজিনালটা লাগবে তো।
মানে the state of West Bengal already recognized this certificate as a valid certificate.
That is not relevant.
When I have completed part 1 and part 2 of the Public Service Commission.
That there is no dispute.
My lord,
there is no dispute on that. That you have been declared qualified by the PSC. That is not in dispute.
My secondary examination, my lord, secondary examination.
Yes.
In the open school Bengal, not only state of West Bengal, all over the India.
Yes.
My lord, that's I have not annexed any other thing. Only their admission.
But you have not shown the tribunal. Why should we see?
My lord,
you have not shown anything like that to the tribunal. Then why should we see?
At that time,
After
my lord,
21 years, 22 years, why should we look into a?
My lord, at that time, my lord, they have admitted, but they have not issued any piece of document. My lord, I have. My
Where
lord,
is the admission at that time? Show us which admission at that time. Come to the records.
kindly
No
see-
supplementary.
Not supplementary. You have kindly peruse the document.
Please show us. You said at that time they had admitted. Where is it? Show us from the document. There is no admission of anybody.
That is page 38. Can you see the government in 1998? He was informed. That is not equivalent.
Yes, he has written to the national school and he has asked them to give a letter that it is equivalent.
But
We have
that
seen
was
that.
letter was issued before, my lord, the state of West Bengal already issued letter to the national opening school that this qualification is recognized by this government of West Bengal.
Recognized and equivalent to Madhyamik.
Equivalent, my lord, kindly see the document.
What is the date of that document?
2000.
Sorry, we will not look into it. We will
Well,
not
at
look
that-
into it.
I have inquired at thereafter. My lord, when the division,
2000 is not relevant. That's why we said 2000 is not relevant.
my lord, kindly peruse the notification issued by the state government of West Bengal.
Show us which document you are.
Here, my lord.
No, nothing after the OA, sir. Be very clear. Nothing. We are not going to allow you to enlarge the scope, bring records subsequent to the cause of action. That is only adding to the unnecessary bulk of the brief. That is for nothing. Futile exercise, why should we undertake? You show us that the recruitment was done in which year?
1994.
94. Now in 94, what was the date of advertisement? It must be prior to 1994, either early 94 or 93. Any document of 93 declaring that yes, this national open school degree is equivalent to Madhyamik, then we are going to accept it even today. Showing us any document.
September 19, we have a document later on. We have wrote there.
We are asking you again and again, show us any document prior to issuance of the advertisement declaring.
No.
Then you have no case. Sorry, nothing can be done. Come. The petitioner's application. Has already. Any can is pending. Can 4 is allowed. That is for recalling the order.
I'm getting.
Item number 9. On the last occasion, Your Lordship directed the Chief Secretary.
Pass over item number 9.
Not in item number 9, Mr. Debra is appearing for the state matter. He is engaged in courtroom number 24. Stealing.
There are the state as well as the writ petitioner, both of them. Let it be taken up. I think today 3:30 is there as well as Your Lordship. That's why tomorrow, if Your Lordship, yeah. Only not today.
Both the matters,
9 and
11.
11. Much more.
Item number 14.
My lord, 14, I am for the petitioner, my
Lordship.
lord. My lord, last occasion, my lord directed to file an affidavit in, but still now I didn't receive the copy, my lord.
Your Lordship.
Lordship, in this matter, Lordship, in this
appearing
matter,
for?
I appear added respondent, Lordship. I appear only for the added respondent,
Let
Lordship.
us understand what is it. We don't remember. Yes. Opposition was to be filed in this matter.
Yes. A report by the Chief Secretary.
Oh.
What is the functioning of the stage of the, there is a committee was constituted, committee could not further because officers were transferred, then the Lordship directed the Chief Secretary.
Now we remember. So what happened?
Now the kindly see page 12 of the report.
No, just tell us why we don't want to see. You tell us what happened.
The committee has been reconstituted and because of some difficulties, new officers came. They have been given 6 months time to complete. Both the parties have been heard. We are waiting for the report from the department.
They have extended.
Mr. Rai has also, client also appeared before the committee.
No.
Why do you need 6 months for this? Why do you need 6 months?
No, till 31st of July.
31st July.
July.
Let them see.
Kindly see the order date. Yes. 31st, within 31st July. Let a copy of the report be given. Yes.
Yes.
We that you will impress upon the authorities to complete the exercise because there has to be a limit.
Yes. Ultimate solution has to be
Yes.
there. Their final adjudication has to be made because so many of secretaries are involved there.
Yes.
কোথায় লিখেছেন 31st জুলাইয়ের মধ্যে কোথায় কোন লাস্ট পেজে
10 members are there.
This was for recommending the service condition of
service condition.
Directorate staff and secretariat staff.
We are the directorate of upper division club, secretariat of, we are the upper division clerk of secretariats.
UDC is in secretariat.
Secretariat.
But they'll not conduct it only for you. They will do it they'll do a holistic exercise for everybody.
No, our contention in the writ petition was that they are treating at par with the upper division clerk of directorate. We are the secretary. Our promotion policy different. Our appointments are different.
Just see page 12.
Page 12. Yes, yes, yes. Further extension up to 31st.
So, we are just wondering, transfer of these employees or these officers is just a routine matter. Somebody may go in, somebody may come out of the committee again. So what step have you taken that it will be done by 31st July? What if again two persons are transferred? Then
Because this committee has been constituted by the about 10 members of secretaries. But whether he is transferred or not, the man will take charge of the one department to another department. The secretary of the department will be there. By name, initially was committee was constituted. Now by official designation.
Then the formation of the committee again will be changed.
No, no. Kindly see. Page 7. Page 7. Who are the members of the committee? All are by designation, not by name.
But this is of 23.
Yes.
After that, you said that because some of them were transferred, it could not be done.
Then country page 9. Only 8 members were there.
So this is also of 24.
Then kindly see.
Oh, this was also by name.
And it has
No, they are the members.
It has
They
been
are the
extended to 31st of
representatives of the federation and all.
they are the representative of our unions,
They are representatives of the
the
federation.
associations.
So this transfer, is it a valid ground to just keep extending the committee's tenure?
No, just to solve the problem once for all. Because there are directorate staff in all over West Bengal, there is secretariat staff all over West Bengal. They are claiming they should not be given the higher benefits to the director staff or should not be given the pay scale.
There are two aspects of the matter.
Check-wise করা হয়েছে যাতে ট্রান্সফার হয়ে গেলে কোনো অসুবিধা না হয়। আরে ওরা অ্যাডেড অলরেডি।
একটু দেরি হলো কেন? কত তারিখ হলো? 2023 অর্ডার। না, এটা তো 2023 সালে। তারা কি ঘুমোচ্ছিল?
How to ensure that, how to inspire confidence that this time it will not be further.
Kindly record my publications that.
No, is there such averment in the affidavit that yes, it will be done by 31st July?
No. The committee.
Please. No. Please.
Committee.
Life has been extended.
Committee's life has been extended.
See, we understand it is not a normal, it is not a thing which can be done overnight.
Yeah.
But there has to be some limit. It cannot be open-ended forever. And this has been going on since last 2 years or more. So why an extension after extension after extension? And how does the court get a opinion or form an opinion on what basis that yes, there is some finality to this report.
Page 10, my lord, last sentence. Concluding discussion, the honorable chairperson advised the representative of all the association to submit their brief write-up on behalf of the association within 3 days before the member secretary and convener for examination finalization of the report of the part of the committee, so that the committee may finally submit its recommendation before the government. Tenures extended till 31st January 2025. Because it could not be completed, that's why when, on 22nd January 25, when it has been extended, so that this taken up.
Whether this is just another extension in the series of
No, no,
extensions or it is an extension,
No.
it does not say was pleased to extend the tenure finally or to submit.
It is positively.
Because 31st January was the last date. It has been extended till 30th July.
Government's pleased to extend the tenure. না একটা জিনিস হচ্ছে সাহেবরা সেটা অবজার্ভ করুন যে নো ফার্দার টাইম মানে আমরা সেটাকে সাজেস্ট করবো না, এইভাবে একটা টপিক সাবমিশন সেটা বলুক যেন দেখা যায় যে এই
Corresponding to one thing. For a can you record that no further extension should be granted. It will do. No. But your lordship got power because of the pendency of the petition for a long time. Issue to be resolved once for all, but no further extension.
Listed view of this notification, be conscious of what has been said in the last 2 lines of the notification. And ask the officers also to be conscious of this because we have seen it. You read the last 2 lines. You please read the last 2 lines.
Now the governor pleased to extend the tenure committee up to 31st July. Within the period, committee will submit recommendation to the government positively.
Positively.
Yes.
So now you are bound by this.
Yes.
Now there is nothing. Yes. In view of the notification dated 22/1/25,
Origin side division bench matters. Appeal from order serial number 1 and 2. Prajul Dotto.
Mr. Mitro, we need not detain anybody else for any other.
I
matter.
don't think so.
Yes, let's proceed.
Yesterday I was placing the writ petition. But kindly take up the volume 1, my lord. I was placing from there.
Yes. Which page you want us to see?
Yes, my lord. Kindly come to page 60, 60. তাই তো প্রশ্ন 60 মিলছে না কেন? $23. My lord, kindly come to paragraph 23, my lord. I'm not very certain about the page number, my lord. 60. 62.
Paragraph 23.
Yes.
We have it at page 60.
Page 60. The said proceedings were sought to be instituted in spite of the fact that the respondent number 6 had given up all his claims in respect of the issue and allotment of shares made by the petitioner number 1 on 12th March 1996 and alteration in the management structure of the petitioner number 1, as will be evident from the correspondence exchange between the advocates. Now kindly turn the page. Kindly come to paragraph 24. In spite of the proceedings pending before the company law board, on the basis of representations made by the respondent number 6, that is Kamul, the respondent number 1, Reserve Bank of India, purported to issue a letter dated 16th March 1998, 16th or 17th March 1998 to the petitioners, requesting the petitioner number 1 to make fresh application to its office in Calcutta to enable the respondent number 1 to issue approval to the petitioner number 1 for allotment of shares against imported second-hand medical equipment on non-repatriation basis in favor of the respondent number 6. Then, my lord, kindly come to, my lord, I am skipping some pages, my lord, which I don't think to be relevant. Kindly come to page 65, my lord, paragraph 25. All the aforesaid facts were also brought to the notice of the company law board in the proceedings, which were pending before the company law board. In spite of the aforesaid, on 26 March 1999, the petitioner number 1 received a facsimile message dated 6 March 1999 from the respondent number 1, intimating the petitioner number 1 that the respondent number 1 had reconsidered the matter and had decided to reinstate the validity of the approval issued by the respondent number 1 on 22nd March 1997 and called upon the petitioner number 1 to treat as withdrawn its later dated 2nd June 1997. So later to the petitioner number 1. Now, my lord, kindly come to skip few more pages. Kindly come to page 72. Yes. My lord, as pointed out to your lordships, my lord, that petitioner number 1 is no more there. The company's name has been struck off. Then kindly come to page 72. In the aforesaid facts and circumstances, the petitioners filed an application under Article 226 of the Constitution before this honorable court, being writ petition number such and such. A copy of the writ petition is annexed. On the said writ petition being moved, an order was passed by this court on 22nd March 1999. A copy whereof is annexed here to marked as such and such. Now, this is at page 225, second volume. Second volume is the first one. The first page of the second volume was just after the index. By this order, this writ petition was in fact disposed of. The writ application arises out of certain permissions granted by the Reserve Bank of India on 22nd March 1997, withdrawn by it on 2nd June 1997, and reinstated by it on 6th March 1999. The approval is in regard to the issue of a large block of shares to the respondent number 4 and an NRI gynecologist in New York. The consideration for the block of shares aggregating some 40% of the share capital of the first writ petition was transmitted to India in the shape of various items of such and such testing machinery. This arrived at Calcutta sometimes in 1994. In the beginning, the Secretariat of Industrial Affairs was approached for import of new equipment, but it appeared that thereafter the parties represented to the authorities that the equipment was demonstration model second-hand. On this basis, the RBI permission would have to be, if at all, on a non-repatriation basis. Now, kindly see what was the stand. That it cannot be on repatriation basis, that is, you cannot take back the money. Whatever money you bring in, that will stay here. That was the case. Now, kindly come to the next page. Second paragraph. Without the approval of the Reserve Bank of India, the issue of shares cannot go through. Thus, whatever decision the company law board or any other appropriate authority might take on the merits of the issue of shares, the first hurdle of the Reserve Bank is the Reserve Bank of India permission has to be crossed in any event. Then, my lord, kindly come to page 405. Towards the middle, the respondent number so-and-so shall grant a personal hearing to the writ petitioners and the respondent number 5 or their duly authorized advocates and take present decision. Now, this was the order passed. Now, kindly come back to the writ petition once again, my lord. Sorry, my lord, I have to shuffle between these two volumes. Now, kindly come to page. Kindly come to page, my lord. I was at page 72. Kindly come to page 84. Paragraph 52. In spite of such contentions having been raised and submissions having been made on behalf of petitioners which were necessary to be investigated and or adjudicated upon the respondents number 1 and 2, as would be evident from the order dated 22nd March 1999, which required particular attention to be paid by the respondents number 1 to 5 as to whether approval would at all be granted or not, whether approval would be of non-repatriation basis alone, whether there would be any monetary limit or limits to the number of shares which would be the subject matter of such approval. The respondents number 1 to 4 under cover of communication dated 10th August 1999 purported to issue an order dated 10th August 1999, wherein the said respondents recorded as follows. Now, my lord, kindly come to this order, which is at page 229. The order at page 229, speaking order by an order dated 22nd March 1999, the Calcutta High Court in petition number such and such has directed the Reserve Bank of India, the third respondent in the above writ petition, to grant a personal hearing to the petitioners, Ruby General Hospital, Calcutta, and the fourth respondent, Dr. K.K. Dotto, NRI investor, and make and publish a reasoned decision in the matter of grant of approval for issue of shares by the Indian company and holding of such shares by persons resident outside India. Accordingly, notices were issued to the petitioner, Ruby General Hospital, Calcutta, and respondent number 4, K.K. Dotto, NRI investor, requiring them to appear before me on 25th May 1999, which was preponed to 22nd May 1999. On the request made by the petitioner seeking time, the matter was finally taken up for hearing on 1st July. Permitting Ruby General Hospital, petitioner Ruby General Hospital were represented by their advocate so-and-so, so-and-so. The NRI investor was represented by his cousin so-and-so. Counsel so-and-so. Starting his submissions, the advocate for the petitioner, RGH, submitted intralab. Then, my lord, these submissions are recorded. Then, my lord, page 233, submission of, my lord, the made on behalf of Kamul are recorded. Kindly come to 235. Paragraph 4. I have given a patient hearing to both the parties who have advanced their arguments in support of their case at length, and I have also gone through the submissions made by both the parties. In the present case, I find that the Reserve Bank of India has a rather limited role under the provisions of the Foreign Exchange Regulation Act in the dispute between the parties. Section 9 of the Act inter alia require any person, which would also include a company, not to issue any share to a person resident outside India, except with the general or special permission of the Reserve Bank. Under the existing policy of the Reserve Bank, permission is given to the Indian companies to issue shares on repatriation basis against the capitalization of import of new equipment or machinery. However, if such equipment or machinery is second-hand, Indian companies are given permission by Reserve Bank to issue shares only on non-repatriation basis. The permission granted to the Indian company to issue shares to the person resident outside India is also treated as permission to such persons resident outside India to acquire or hold such shares under section such and such of the Act. Admittedly, in the present case, the imported equipment was second-hand. Therefore, Indian company, that is Ruby General Hospital, have Reserve Bank of India's permission to issue share to K.K. Dotto, investor, on non-repatriation basis. I therefore hold that the Indian company Ruby General Hospital, Calcutta, has the RBI's approval for allotting the shares to Dr. K.K. Dotto and for Dr. K.K. Dotto to acquire and hold such shares only on non-repatriation basis. However, if and when such shares will be issued or allotted to the NRI investor, Dr. K.K. Dotto, is a matter to be decided by the Indian company. So it was left to the company. Then, my lord, kindly once again, sorry, my lord, kindly come back to the writ petition once again, my lord. I placed paragraph 52 at page 84. Kindly come to page 86. The respondent in purporting to pass the said order dated 10th August 1999 failed to comply with the directions contained in the order dated 22nd March 1999 passed by this Honorable Court. Now, my lord, the direction was that the general manager will hear. Instead of the general manager, my lord, it was heard by the executive director because according to Reserve Bank, my lord, he was the person competent to take the decision. And they participated there. He's a higher authority, he participated. And they participated before him. Then paragraph 55. The order dated 22nd March 1999 required hearing to be given by General Manager of Exchange Control Department, Reserve Bank of India, having his office. Respondent number 2 herein, however, no such hearing was given by the respondent number 2. Then, my lord, kindly come to page 98. Paragraph 76. In such circumstances, the petitioner being aggrieved by the order dated 10th August 1999 filed an application under Article 226 of the Constitution of India in this Honorable Court, being writ petition number such and such, praying for various reliefs, and would appear from a schedule containing the said reliefs annexed hereto. 77. On 3rd September 1999, an order was passed by this Honorable Court directing any action taken pursuant to the said impugned order dated 10th August 1999 to abide by the result of the said writ petition. Directions were also given for filing affidavit. On 13th September 1999, a further order was passed by Honorable Justice so-and-so in WP number such and such, modifying the order dated 3rd September 1999 to the extent that any action or proceeding taken on the basis of the said impugned order dated 10th August 1999 to abide by the result of the said writ petition. Thereafter, affidavit in opposition, etc. Then, paragraph 80. On 23rd February 2004, an order was passed by this Honorable Court in WP number such and such, setting aside the order dated 10th August 1999 passed by the respondent number 4, as the same was not in accordance with the order dated 22nd March 1999. Now, my lord, this order, your lordships will find at, my lord, page 237. $239, yes. Really 239. By this lordships got that?
Yes.
239. Order dated 23rd February 2004. By this application, the petitioners have challenged an order dated 10th August 1999 passed by the Executive Director of the Reserve Bank of India, purported to be in compliance of the interlocutory judgment and order passed by His Lordship so-and-so on 22nd March 1999 in another writ petition being number such and such. It appears the first mentioned writ petition is still pending. The aforesaid order has been challenged by filing the instant writ petition separately, keeping the previous one pending. Various grounds have been taken to challenge, touching the merit and legal aspect as well. When the matter came up for hearing before this court on 12th December 2003, this court felt that the preliminary question raised by the senior counsel for the petitioner has to be decided before I enter into the merit of the case. As in the event the preliminary point succeeds, hearing of this matter on merit will be unnecessary. As such, I heard this matter on preliminary point as to whether the order passed by the Executive Director is sustainable on the question of authority and jurisdiction in the context of the judgment and order of Justice Ray on 22nd March 1999. The subject matter of the writ petition relates to the question of approval, etc. Kindly, my lord, omit that. Let kindly come to page 242, my lord, the submissions made on behalf of Reserve Bank of India. The learned senior counsel appearing with so-and-so appearing in support of RBI supports the order impugned. On this point, he says that under the rules of business as framed under the RBI Act, this type of matter is normally dealt with by the executive director, who is the superior to respondent number 3 in hierarchy. The intention of the court was that the matter ought to be dealt with by the appropriate authority of RBI, meaning thereby the said executive director as the respondent number 3 never deals with the matter under the rules of business. Therefore, he says the order is not bad, and this has been passed in consonance with the desire of this court. Moreover, he submits that the writ petitioners, having participated in the hearing, took chance and they are stopped from raising question of his competence. This point has been taken desperately, having found that order has gone against them. In support of his submission, he has relied on such and such. He has also produced the relevant rules as well as the information showing the hierarchy of the officials. From the information, it appears that executive director stands in the 4th position in the hierarchy, whereas the general manager, namely the respondent number 3 herein, stands in the 5th position. The relevant rule shows that the executive director has authority to decide the matter of this nature. The learned senior advocate adopts the argument of Mr. Mitra in substance, and additionally he contends that the intention of the court was that the appropriate officer should deal with the matter, and so it has been done. The petitioners are stopped from raising these questions as they have waived their right to object to the authority and jurisdiction of the executive director. At the highest, it may be irregular, but it is not an illegal and void ab initio. The court will ignore this irregularity. Then, my lord, ultimately it was kindly come to, my lord, page 248. As rightly argued by the learned counsel that when the law requires a thing is to be done in a particular manner, this has to be done in that manner alone or not at all. In an unreported decision of the division bench of this court, while dealing with the jurisdiction of the chief electrical inspector under the Indian Electricity Act, since repealed, in the context of the order passed by the court in writ jurisdiction, it has been held that the person chosen by the court has to decide the matter irrespective of the provision of the Indian Electricity Act, etc. Accordingly, I hold that the impugned order passed by the executive director is of no value and the same is non-est, irrespective of provisions of the rules of business. This order could have been examined by the court had it been passed by the respondent number 3 in terms of the order of justice. Now then it again comes back. Now, my lord, I do not want to place, my lord, the rest of the writ petition. Kindly come to page 159, the prayers in this writ petition. Kindly come to page 159. Page 160, writ of and or in the nature of mandamus do issue calling upon the respondents number 1 to 5 and each one of them to forthwith revoke, rescind, recall, cancel and or set aside the orders dated 23rd April 2004 and 7th May 2004. Well, that is the prayer, basically. Now kindly come to these two orders, my lord, 23rd April 2004 and my lord 7th May. Kindly come to page 254, second volume. Twenty-third April is, my lord, according to me, not very relevant, but kindly come to 254. Kindly come to. It is quite surprising for me to note that at this stage you require some documents now, and this plea was never taken by you before the Honorable Justice so and so, as well as Honorable Justice so and so of Kolkata High Court. At this stage, when the Honorable Court has fixed a deadline date for giving a reasoned order in the matter, and also since the requests do not fall within the ambit and scope of court direction, I therefore am not in a favor of providing further documents or any duration of time on the pretext that certain documents are required from Reserve Bank of India. Now, my lord, the documents which were sought for, kindly come to page 251. Kindly look into the subject, my lord, nothing further. Subject: request for all documents and correspondences from Reserve Bank of India, Kolkata and Mumbai from period 1995 to 2004 by Dr. K.K. Dotto, Mr. Arun Saini and others like so and so who have made unauthorized representation on behalf of Rupee General Hospital behind the back of the company regarding permission, etc. All documents. And this was refused. Now kindly come to the final order, which starts at page 257 or 258. At the top, Lordship should find permission for issue of such and such. Ruby General versus Reserve Bank of India. Background, my lord, kindly skip the background. Kindly come to, my lord, at the bottom of page 259. Hearing on 22nd April 2004. The hearing commenced at such and such on 22nd April 2004 in my chamber. The petitioner, RGHL and Sri Shajul Dotto, were represented by so and so. At the outset, the undersigned read out the relevant observations made in WP number such and such and called upon Mr. Sri Shajul Dotto to make his submissions. He has been given a very patient hearing, etc. My lord, I am omitting that. Okay. At the top, Lordship should find, my lord, appearances, Managing Director, Shajul Dotto, Shushomon Dasgupta, Technical Director, Subhash Mukherjee, Director, Partho Ghosh, Executive Director. As Director, not in his personal capacity. Then, my lord, kindly come to, my lord, his submissions are made, kindly come to page 263. At the bottom. After making the above submissions for the whole day, from 11:30 a.m. to 5:30 p.m. on 22nd April 2004, Sri Dotto asserted that unless he was provided with copies of whatever communication that might have been exchanged between RBI and Dr. K.K. Dotto from 1997 till date, he could not proceed further in his submission, and that he was going to submit this in writing as an official request for the transparency of this case. Thereafter, he submitted a letter dated 22nd April 2004 in which he requested for all documents, etc. Then next paragraph, representative of Dr. K.K. Dotto strongly objected to the petitioner seeking for all probable documents without specifying the particular document on which they want to rely. As such, roving and flushing inquiry was not permitted in law. He also demanded that if at all any document was given to the petitioners, the same should be given to them. Then, my lord, hearing on 23rd commences. Submissions are recorded, my lord. Kindly come to, my lord, page 271. The order at the bottom. I have given a patient hearing to both the parties, the petitioner Sri Shajul Dotto during his submission, which covered the whole of 22nd April 2004 and the first half of 23rd April, had made long submissions at the conclusion, etc. Now kindly turn the page, my lord. Again, recordings are there. Kindly turn the page, 272, the second paragraph. I am of the opinion that the Reserve Bank has a rather limited role under the provisions of FERA 1973 in the dispute between the parties, and there are three issues to be addressed. I will address them serially as follows. First issue, whether approval shall at all be granted or not. In terms of section 19(1)(d), any person, which includes a company, has to obtain RBI's permission before issuing shares to a person resident outside India. Section 19(1)(d) of FERA 1973 reads as follows. Notwithstanding anything contained in Section 81 of the Companies Act 1956, no person shall, except with the general or special permission of Reserve Bank of India, issue, whether in India or elsewhere, any security which is registered or to be registered in India to a person resident outside India. From the above, it is clear that any person, which includes a company, can issue shares to NRI only with the prior permission of RBI for issuance of such shares. The issuance of shares can be on repatriation or on non-repatriation basis. RBI permitted issuance of shares on repatriation basis when foreign remittance was received through normal banking channel, or when there was capitalization of new equipment supplied by the NRI. If the equipment supplied were second-hand, then the capitalization of the same was allowed on non-repatriation basis. Admittedly, in this case, the equipment supplied by Dr. K.K. Dotto were second-hand, and there is no dispute on this point. SIA approval was obtained on 6 August 1993, in which non-resident equity participation allowed is 88.88%. SIA later also states that project envisages import of capital goods worth rupees 420 lakhs to be financed out of the NRI investment. The import of the equipment was governed by the then EXIM policy, in terms of which there was no restriction on import of second-hand capital goods. Thereafter, on 4th November 1993, in principle approval was granted by RBI for issuance of shares on repatriation basis. During the financial year 1994-95 and 95-96, Dr. K.K. Dotto supplied imported second-hand medical equipment and applied for share against the second-hand equipment. The import of such medical equipment against which shares were to be issued, pending RBI permission for the same, was reflected in the annual report and balance sheet of the company for the years ending 31st March 1995 and 31st March 1996. This fact was also known to Sri Shajul Datto as he had signed the above balance sheets as director of the company. The above balance sheet also showed income over rupees 100 lakhs from out of the operation of the hospital, obviously with the use of equipment supplied by Dr. Datto and commissioned by the hospital. The permission granted by RBI vide its later dated 22nd March 1997 was on the basis of Ruby General's application dated 17th March 1997, signed by Dr. K.K. Datto as the chairman of the company, enclosing thereto all the requisite documents. The same was scrutinized by ECD RBI, Kolkata, as at that point of time, the regional office of RBI were delegated with the power of approval for permission for issuance of shares on non-repatriation basis. Permission was granted by RBI Kolkata after scrutinizing all the required documents submitted by Ruby General and after finding the same to be in order. At that point of time, RBI Calcutta did not have the information that Dr. Komul Kumar Datto had ceased to be the chairman of the company, and there was a board resolution of the company not to apply for shares against second-hand equipment. Hence, the act of RBI Kolkata was based on documents, papers signed, submitted by Dr. Datto, representing himself as the chairman of the company. Therefore, the aforesaid permission was granted in good faith and without negligence. Dr. Datto took delivery of the permission letter, etc. Sorry, may I please it? Dr. Datto took delivery of the permission letter addressed to Ruby General in original personally, which was given to him as he represented himself as the chairman of the company, and as such, the letter was not posted to the company at the registered office address. The permission was objected to by Ruby General, represented by Shajul, the managing director of the company, vide its later dated 26 May 1997, mainly on two grounds mentioned earlier. RBI Kolkata withdrew the approval letter dated 22nd March 1997 on the basis of this complaint. However, RBI Kolkata, in good faith, believing in the representation of Shajul Datto, withdrew the approval letter issued to Ruby General and handed over Dr. Datto on 22nd March 1997 by issuing another letter dated 2nd June 1997, a copy of which was endorsed to Dr. Datto. Dr. Datto represented against the same. The representation was examined by the bank and a decision was taken to maintain status quo ante in view of the fact that Dr. Datto, NRI investor, has already made payment to the suppliers of second-hand machines abroad. The aforesaid decision of the bank was communicated with a letter dated 6 March 1999 to Ruby General and copy endorsed to Dr. Datto. Incidentally, the CLV with its order dated 29th October 1999 has held that Dr. K.K. Datto has not vacated his office as chairman and as such restored Dr. K.K. Datto as director chairman of the company and has nullified the board meeting in which the decision was taken for not applying to RBI for issuance of shares against the second-hand equipment. This order of CLB has not been stayed or superseded or nullified by any court of law which has been confirmed by Sri Shajul Datto. Pausing here for a moment, my lord. Ultimately, this order was upheld by the Supreme Court, the order I had placed yesterday. Therefore, on the date of application, that is 17th March 1997, Dr. Datto was the chairman of the company who had duly applied for permission for issuance of shares on non-repatriation basis, for which the permission was granted. In view of the above, I am of the opinion that the RBI permission for issue of shares shall be granted in terms of section 19(1)(d) of FERA 1973 through Ruby General. The permission granted to Ruby General to issue shares to the person resident outside India shall also be treated as permission to such person resident outside India to acquire or hold such shares under section 29(1)(d) of the Act. So, my lord, permission was granted to Ruby General to issue shares. There was no direction.
Yes.
Even after this permission, it was open, my lord, to Ruby General, my lord, either to issue or not to issue. Reserve Bank of India, my lord, had nothing to do with that. The petitioner number 2, my lord, his complaint is that his shareholding has been reduced or is being reduced. Because of this order, my lord, in my respectful submission is not correct, and he cannot have any locus standi to challenge this order, simply because this order did not give any direction on, my lord, Ruby General to issue the shares. Or, my lord, Ruby General issued shares on the basis of any direction given by Reserve Bank of India. No such direction was given. It was simply a permission.
Yes.
Now, my lord, as I have submitted before your lordships have seen that the writ petition was filed initially by Ruby General and Shojul. Then, my lord, name of Shojul was deleted. Sorry, Ruby was deleted. I'm sorry. Ruby was deleted.
Yes.
Now, my lord, on deletion of Ruby's name, my lord, I have shown your lordship the writ petition. According to me, my lord, there is not a single affirmation in the writ petition which does or can give any cause of action to Shojul to continue with the writ petition.
This is of 7/5/2004. This order is dated
Yes. This is the order impugned in the writ petition.
Yes.
Then, my lord, second issue, kindly see page 275. Whether the approval shall be on non-repatriation basis alone, as discussed above, the equipment supplied by Dr. K.K. Datta were second-hand. The company had received and utilized the same for which Dr. Datta had made payment abroad. Since, as per the then existing policy of RBI, capitalization of second-hand equipment could be permitted on non-repatriation basis only. I am of the view that permission shall be granted for issue of shares on non-repatriation basis alone. Though there was conflicting claim and counterclaim regarding functioning or functionality of the medical equipment or its valuation, etc., by both the parties producing various documents and papers in support of their own stand, I am of the view that it is beyond the scope and purview of my investigation to delve into each and every claim and counterclaim.
Yes.
Now, my lord, yesterday I had placed before your lordships, my lord, the minutes of the meeting held on 16th of September 2006, which was held on the basis of the Supreme Court order and in which, my lord, decision was taken to issue the shares. But kindly once, it's a small minute, my lord, kindly once come to page 367. I showed this yesterday.
Yes.
Kindly come to 368 to implement the direction issued by Honorable Supreme Court of India in their judgment dated 11th August 2006, board resolution dated such and such. The chairman tabled before the board the order, judgment dated 11th August 2006, passed by the Honorable Supreme Court of India, and stated that though the copy of the same was sent to the director with the copy of the notice, yet he thought to highlight the operative part of the judgment, as stated on pages 60-61 of the order. He therefore informed the board that the Honorable Supreme Court of India was pleased to set aside all the resolutions with regard to raising of funds dated 19th April 1995, removal of Dr. Binod Prasad Sinha from the Board of Directors, outstripping of Dr. Kamal Kumar Datta from the Managing Directorship, allotment of shares to Shajul Datta's companies and to others, and to all resolutions which adversely affected Dr. Kamal Datta and Dr. Binod Sinha. The matter was noted, discussed, and the following resolution was passed unanimously, resolved unanimously that item number 9 in board resolution dated 19th April 1995, titled Subscription to Equity Share Capital within the Authorized Capital, and resolution passed in EOGM dated such and such in pursuant to alleged board resolution dated 19th April, be and is hereby cancelled and revoked. Resolved further that all other resolutions arising out of the said resolution, such as board resolution dated such and such for allotment of shares, as to be taken as next item, also stand cancelled and revoked to the extent stated in the respective resolutions. Sorry, page 369.
Yes, yes, we have it. We are with you.
Now, my lord, this was challenged by Shajul before the company law. Now, kindly come to the order passed by the company law board, my lord. Once, my lord, that starts at page 406 of this volume.
Which page you said?
406. Page 406, my lord, kindly come to the first part, then I shall. It is second round of litigation. First petitioner Shajul Datta, hereinafter called as Shajul, initiated this CP 53 of 2007 against respondent number 1 company, namely Ruby General. His brother, called Dr. Kamal Kumar Datta, hereinafter called as Kamal. Another shareholder called Dr. Binod Prasad Sinha, hereinafter called as Sinha, and another person continuing as director called Arun Kumar Saini, etc. Then, my lord, kindly come to next page. Paragraph 2. Case of Shajul is that Ruby was incorporated on 1st April 1991 with an authorized share capital of rupees 5 crore, divided into 50 lakh equity shares of rupees 10 each, with a paid up capital of rupees 98 lakh 24,700, divided into 9 lakh 82,470 equity shares of 10 each. The company has come into existence to set up a hospital at Koshba, etc. Shajul is a graduate mechanical engineer. Well, the descriptions are given, my lord. He is very qualified, definitely. His graduate mechanical engineer with postgraduate degree in business administration from Indian Institute of Management. He established his own companies in the area of manufacturing and export. He received award for his excellence in export business from the Union Ministry of Commerce in the year 1993 and from the State Union Minister of Commerce in the year 1994. He is younger brother of Komul. P2 and 3 are the group companies of Shojul. All these three are together holding such and such shares of rupees 10 each, amounting to 47.03% in Ruby. He submits that the total number of shareholders in Ruby are 7 in number. Komul is permanent resident of United States, practicing as medical doctor. Prior to the wrongful and illegal allotment on such and such, Komul held 4,55,653 equity shares of rupees 10 each, amounting to 46.37, whereas Shojul Group held 47.3%. However, Komul has now wrongfully claimed to be the owner of such and such. Then, my lord, kindly come to, without going into the facts, kindly come to page 420. The submissions are recorded, my lord. Paragraph 33. Before going into the merits of submissions made by the council, I believe I must place backstory and facts I believe as correct. I have called out it from the observations made by this company law board in the previous order, the Honorable Supreme Court of India in the judgment dated 11th August 2006, and from the documents placed by the parties. I need not say separately, this tribunal has come into existence to ease the litigation from the bottlenecks of civil procedure. I don't say tribunal is wholly free from CPC, etc. Then, my lord, kindly come to 422, paragraph 37. The bottom line for adjudication of a case under section 397 and 398 of the Companies Act is whether any act has been done with an oblique motive to solely cause harm to the other, or done in ordinary course of action to fulfill the obligation and commitment already entered into, or to comply with past obligations. No doubt such follow-up action might make somebody felt lost something. On this premises, I say backstory is more important to adjudicate on the action impugned, rather clinging to who pleaded what relief asked, what relief not asked, what is traversed, what is not traversed. The reality is history of facts will not change by either pleading or no pleading. At the end of the day, truth prevails over everything. One's court comes to know what truth is. It is no big to know what law is applicable, what is not applicable. Then, well, let's kindly turn the page. Paragraph 39. Komul and Shojul are brothers. Komul has settled in US as a doctor, whereas Shojul is comfortable in India with his business. Both are well-read people, thriving well in their positions. I have noticed initially, Komul and his friend Sinha, who is another doctor working in US, made up their mind to set up a hospital in Kolkata. In pursuance of their idea, they took in Shojul and started a company, making Shojul as resident Indian shareholder. All these three initially agreed to have 88.88% paid up capital from NRI and 11.12% paid up capital from Indian residents. Out of 88.88%, it was agreed that 44.44% through medical equipment and 44.44% through cash from NRIs. Remaining 11.12% capital would be from Indian residents. When series of events happened, the intention of the parties could be deducted from the act of them through the understanding arrived. Though the understanding arrived does not go down into writing. Sometimes contracts are implicit and sometimes they are express. As we know, the validity of the intention will not change, notwithstanding the fact that the mode of contract is express or implied. All this is evident from the application schedule in the capacity of director made to SIA for permission to NRI to invest in Indian business. Now, my lord, pausing here for a moment, my lord, kindly once come to this application. My lord, here application. Kindly come to page 166, my lord, the first volume once, my lord, pausing here for a moment. First volume.
Yes, the application.
Yes, the application, my lord. Kindly see the application, Ruby General. Now kindly come to page 168. Pattern of shareholding, my lord, towards the top, lordship should find total rupees 9 crore. Then, my lord, kindly come to foreign holding nil, preference nil, then B, non-resident Indian, repatriable 40 lakh, preference 40 lakh, percentage total comes to 88.88%.
Perhaps 4 crore each, not 40.
Sorry, my lord, yes. Total 4 crore, yes. Yes, my lord, I'm obliged. Then non-repatriable, etc. Then resident holding. This is 50 lakhs and 50 lakhs. Total 1 crore. Percentage is 11.12%. And then, my lord, kindly come to, lordship should be pleased to come to page 175.
Yes.
Lordship should find, my lord, the name of the authorized so-and-so, State Bank of India, then declaration for Ruby General Hospital Limited, Sojol Datto. It was on 31st of May 1993 when, my lord, there was no dispute. And application by Ruby General, by none else. Now, my lord, kindly come to the next document, my lord. Kindly come to page 176. This is the permission which was granted by the ministry to Ruby General. Page 176.
Yes.
Now, my lord, kindly come back to page 423, my lord.
Yes.
My My lord, I was placing towards the bottom. All this is evident from the application schedule in the capacity of director made to SIA for permission to NRI to invest in Indian business. He categorically mentioned in the SIA application dated such and such that such and such crores is the authorized share capital, out of which paid up capital would be rupees 9 crore. Out of this 9 crore, NRIs would invest 4 crore through cash and 4 crore through medical equipment, and remaining 1 crore would, sorry, my lord, page 423.
Yes, and remaining 1 crore would be from
Lordship, my lord, would be from Indian shareholder. He also stated that the chief promoter of the business is Dr. Kamal Kumar Datto, and he said foreign investment of rupees 8 crore would be from Kamal's group. Here in the case, the argument of Shajal is slightly warped to impress upon the bench that 88.88% to NRI is only ceiling limit. It is nowhere said that foreign investment would be 88.88%, that is 8 crore. But to me, despite reading that application many times, I could not come to any other inference except to an inference to say that foreign investment would be rupees 8 crores, amounting to 88.88%. It is not sounding anywhere in the application either the foreign investment would be up to 88.88% or Indian resident shareholders could have more than 1 crore or more than 11.12% shareholding. By the time this application schedule made to SIA on 31st May 1993, the hospital did not see the light of the day because the hospital was inaugurated on such and such 95 only after arrival of the second-hand equipment from US. In support of this application signed by Shajol, Kamal also filed a handwritten letter to Shajol to one Vijay Kumar Gupta on 25th August 1993, saying that entire 88.88% of share should be allotted to Dr. Kamal Kumar Datto on repatriation basis. So it could be clear as early as in 1993 that Shajol was privy to the decision for issuance of shares on the basis of 48.44% capital in cash and 44.44% capital in kind through medical equipment from NRI on repatriation basis. In pursuance of this understanding, Kamal infused capital into the company through cash and equipment in the year 94 and 95 by importing medical equipment valued around rupees 3.5 crores. Apart from this, the balance sheet as on 31st March 1995 discloses the value of the equipment imported as on 31st March 1995 was shown as share application money to be allotted for consideration other than cash, and this was signed by Shajol himself. In the notes on accounts for the year ended 31st March 1995, it is said, share application account represents funds received in cash or in kind from Kamal as NRI against which equity was yet to be issued pending receipt of approval of RBI under FERA 1973. The above sum also includes rupees 74 lakhs, which was initially credited to the share capital account, but later it has been shown as share application account money, pursuant to the resolution passed by the board pending receipt of the approval of RBI. The notes was signed by Shajol himself in the capacity of director. Even the balance sheet dated 31st March 1996 discloses the fact that rupees 3 crore 74 lakh 33,580 is pending as share application money to be allotted for consideration other than cash. Thereafter, Shajol made allotment unto himself on 12th March 1996 and 24th July 1996, reducing his brother and chief promoter of the company to minority. Knowing well, Indian resident shareholding shall not be more than 11.12% capital in the company. Had really Shajol, aggrieved of seeing second-hand machine coming to the company, he should have challenged the same before some court of law, but on the contrary, to preempt Komul from having 88.88% capital in the company as agreed before, he hurriedly allotted shares to himself, making himself majority, and ousted his brother altogether, which the Honorable Supreme Court held as full proof of oppression. In paragraph 10 of the company petition, Shajol says, Komul did not disclose to the board of the company that the imported equipment is second-hand. The invoice of this equipment do not mention that the equipment is second-hand as required under the Customs Act. Had there been any objection over the equipment by Customs Authority, this objection should be somewhere in the year 94 and 1995. Since Shajol was on the board and looking after the affairs of the company, he should have been aware of the same. Therefore, this bench infers he has been aware of this fact. Having known this fact, what action he took against same from 1994 until he filed writ petition in the year 1990, until the year 1999 before Honorable High Court at Calcutta. Had the equipment been objected at customs on the ground equipment is second-hand, what action the Customs Authority had taken, upon which Shajol is silent? One thing is fact, Customs cleared the equipment and hospital was inaugurated only after most of this equipment was set up in the hospital. That time Shajol had no objection to see this hospital run on this equipment. Shajol says he discovered this fact only after IDBI wrote a letter to the company on 4th April 1996 to the letter dated 9th February 1996 written by Komul saying the equipment is second-hand equipment. Assuming he came to know this only after IDBI wrote a letter to the company on 9th April 1996, why Shajol later also kept quiet, except writing a letter to RBI not to give permission to the company to issue shares to Komul? Had Komul said anywhere that equipment would be new one, this equipment became dysfunctional, obsolete or obsolete to Shajol only when Komul initiated action against Shajol, challenging the allotment made to Shajol himself is bad. The Honorable Supreme Court held, the Supreme Court's order is quoted, my lord, I am not going into that. Kindly come to page 426, first paragraph, last 4 lines. Therefore, it would not be right on my part to make any additional observation over it when Apex Court already observed in the first round of litigation over this aspect, saying what could be more oppressive than preventing Komul from having shares issued to the equipment supplied by him. Let us see the observation of the Supreme Court, then observations are set out. Kindly come to page 428. Fact of the matter is, paragraph 41. Fact of the matter is, Shajol moved writ after writ to stall Komul getting shares issued to the medical equipment, and he has remained successful in halting shares going to Komul to the equipment till date from 1996. I should not say separately when the Honorable Supreme Court itself held that hospital was inaugurated with the equipment which came from Komul. In fact, the company started making profit with the same equipment, and that comes from Komul. The same equipment that comes from Komul. The capital that has come into the company in the form of equipment is subsumed in rendering services and bringing in profit to the company. One thing is clear that The value of the equipment could not be converted simultaneously into capital for only one reason, that is for want of RBI approval. That approval is in no time came to the company for conversion of rupees 3.5 crores into capital or non-repatriation basis. But by that time, Shojol already played his card well by ousting Komol from the company and made allotments to himself, making himself as majority. Not only that, through though RBI approval issued on RBI approved issue of 30,55,329 shares to Komul in consideration to the second-hand equipment supplied to the company on non-repatriation basis. Till date, shares were not issued to Komul, since the Honorable Supreme Court held that Shojol acted prejudicial to the interest of Komul and his acts are oppressive against Komul, since Komul is allowed to continue to act as MD of the company and pass resolution within 21 days in accordance with law. Komul, in pursuance of it, passed a resolution on 16 September 2006 allotting shares to him in consideration to the equipment he supplied to the company in the year 1994 and 1995. This is what the truth is. Now, the grievance of Shojul in this company petition is allotment of shares to Komul in consideration to the equipment supplied by him is in contravention of section such and such of the Companies Act. Therefore, this bench has taken it as the first issue. The first issue, whether the issue and allotment of 30,55,329 equity shares each to Komul Kumar Dattu in a board resolution. This is the issue, my lord. Now kindly come to, my lord, then the submissions are recorded. Till page 431, kindly come to page 432. Paragraph 49. Initially, Shojol himself as director of the company.
49 is at page 432.
Sorry, 432.
Yes.
Sorry. 432, paragraph 49.
Yes.
Initially, Shojol himself as director of the company simultaneously captioned the second-hand equipment. Simultaneously captured the second-hand equipment as capital when it came to India. I need not reiterate in my order to say that the apex court of us has not means towards in saying that an attempt was made by the younger brother Shojul to oust the elder brother by denying him his shares for the medical equipments worth rupees 3.5 crores supplied by him from USA. I have already placed Apex Court's observation over supply of second-hand equipment in the order dated 11th August 2006 over the very same issue, which Shojul now complaining in this petition on two fronts. One, it is second-hand and obsolete equipment, therefore it should not be converted into capital. And two, it is not in compliance of Section 81, Section 299 and 300 of the Companies Act. On seeing such an observation on the same issue from the highest court of this country, can anybody say this second-hand equipment is unfit to become capital? I only can say by reading the judgment of Honorable Supreme Court that the company had no qualms when the machinery came to the company, with which when it got a shape of hospital, and rather this hospital continued it with for some time, it had only become obsolete and overrated when it got into the mind of Mr. Shojul to become majority in a company set up by his brother Komul. On this allegation, he landed up in Honorable High Court at Calcutta with a writ petition saying Reserve Bank of India did a mistake in permitting the company to consider the value of the second-hand machinery as capital in the company, to which RBI held that HON'BLE is entitled to allotment of 30,55,329 shares to second-hand equipment on non-repatriation basis. Of course, the Honorable High Court first directed RBI to hear schedule and pass orders. When RBI struck to its stand, saying second-hand equipment is good enough to become capital by saying such finding, schedule filed another writ saying the officer issuing order is not, the officer who issued the order is not competent to pass orders. Then on the order passed by the Honorable High Court in such and such, RBI passed another order reiterating that the company shall issue these shares. My lord, can I have, my lord, 10-15 minutes time on any other day, my lord?
Yes. You tell us when.
Any day could be.
Any day means convenient to both parties. For us, every date is convenient.
কবে কবে করতে চাই কালকে আমার দুটোর সময় অসুবিধা আছে
সকালে করবি কিছু তো বলো। Can it be in the morning tomorrow, my lord? If it is, we do not know.
Morning, we don't want to take up these matters because all the morning may not be possible, sir. Tomorrow. Oh, tomorrow, original. So tomorrow, perhaps another signed original matter is already fixed at 2 p.m.
Oh, very well, my lord. 2 p.m. Then, my lord, can it be on Tuesday?
very well ma'am.
For further submissions, list on Tuesday. Give the date of Tuesday. Don't say